And welcome to this unique virtual training on workplace discrimination. With us today, we have 6 wonderful trainers, including myself, Daily Mesa. We also have Jennifer Diaz, Jeffrey Gabriel, Maria Herrera Mendoza, Luis Parra, and Melissa Romero. To begin the training, I'd like to share with you a brief definition on what exactly discrimination in the workplace is. Discrimination is any workplace action such as hiring, firing, demoting, and promoting based on a prejudice of some kind that results in the unfair treatment of employees. Discrimination is strictly prohibited by a great number of federal laws. Stated here, we have certain solutions for LGBT employment discrimination in the workplace. This is one of the most common discriminations in the workplace, so we have some solutions that can help decrease the discrimination amount. We have policies and laws recently adopted, the Employment Non-Discrimination Act, which bans discrimination based on sexual orientation and gender identity in the workplace. We need to reprimand any discrimination who is shown towards an LGBT person. If an employee does become present of an discrimination towards an LGBT person, please report it to a supervisor or a member of the Human Resources Department here at our company. Invasion of privacy, defamation, harassment, and emotional distress are all prohibited. Please educate. Apart from all the trainings that the company does offer, such as this one, and workshops for the company, please feel free to educate anyone who is not aware of what LGBT stands for or the hardships that they face in the professional world. Listen, always keep your door open for LGBT people. Allow anonymous submissions for those who are not comfortable speaking their thoughts.
Okay, now I'd like to talk to you about equal employment opportunity, really with regards to hiring practices. This is somewhere where we see a lot of discrimination cases nowadays. So equal employment hiring really is about making sure that we recruit, hire, and promote the best qualified person for that job. And that's without regard to sex, sexual orientation, age, race, national origin, pregnancy, veteran status, genetic information, religion, disability, any of those other characteristics protected by law, just like any discrimination case. So the regulations that pertain to this are the same regulations that limit a lot of our discrimination cases. So the Civil Rights Act of 1964, the Equal Pay Act, the Age Discrimination and Employment Act, along with the Americans with Disability Act as well. So really, when it comes to hiring and making sure that we don't discriminate, the largest area of opportunity is generally in the interview process. This is where you'll see questions being asked that don't pertain to the applicant's abilities or the job, and that's where we can get into some trouble there. So companies are not allowed to ask any personal information in an interview if it's not related to the job. So really, it's designed to make sure we don't select or promote or hire anyone based on those characteristics. So some questions that you cannot ask, things like how old are you pregnant, do you have children, would it bother you to have a boss younger than you, do you have any religion issues that prevent you from coming to this job. Anything that doesn't have something to do with the job cannot be asked during that interview. So companies really need to make sure that they spend time teaching their team members and their managers on how to properly interview applicants to prevent those lawsuits. So the only criterion for consideration in applicant selection is the applicant's qualifications and the ability to perform the job. That is it. A lot of companies get into trouble not only during that interview process, but also afterwards when they're turning down the candidate and they're giving them the reason they're not being hired, and then they choose one of those protected characteristics, or they say something involving something that doesn't have to do with the job, and so they get themselves into trouble that way. So it's also important to teach not just only the interview process, but also the whole talking to the candidate after the interview or before the interview that could get people into trouble. So really, that's the equal opportunity employment portion workplace discrimination.
The outcome of workplace discrimination is never good. Not for the employer and not for the employee. If an employer is charged with workplace discrimination, there are laws to make sure that they come to justice. Title VII of the Civil Rights Act of 1964 is a federal law that prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. This law applies to employers with 15 or more employees, including federal, state, and local governments. Which brings us to the case of Nicole Cogdell versus Wetzel. Nicole was harassed because of her race, constructively discharged, and replaced with a higher paid, less qualified white woman. Nicole claims to have read an email from a Wetzel executive saying that the store she was working in had too many blacks, and Nicole especially was not suitable for the store. This caused an immense amount of stress on Nicole, leading her to take some time off the job. When she returned, Nicole declares that she was basically attacked with the amount of concern her co-workers had about the issue. Allegedly, corporate managers had no shame in showing their interests were solely on thin, white employees with blonde hair and blue eyes. Nicole had no choice to resign. And this case actually cost Wetzel $7.5 million. And now Wetzel has a bad reputation, and Nicole is now traumatized for just being herself. Now, there was another case on Hubbard versus USPS. Upon getting hired, an employee signs a contract acknowledging their rights, safety, and consistency of treatment. As an employer, it is our responsibility to make sure that we follow what we offer from the beginning to the very end. Being deaf or some sort of hearing impaired qualifies you for the American Disabilities Act. And if the individual can perform a certain job but needs some sort of accommodation to perform it effectively, the employer must take that into consideration. And the U.S. Postal Service is being sued due to the fact that it did not provide reasonable accommodations to its deaf and hearing impaired employees. Of course, USPS still hire these individuals looking past their disabilities, but where USPS is held at fault is when several complaints had been made to help these employees work efficiently, and they chose to neglect them instead of providing them with any technology or service that would have helped them perform their duties. It is no doubt that they lost this case, and a Washington federal judge gave final approval to a settlement agreement requiring USPS to have to pay $4.5 million to end this 10-year case. And without a doubt, the court found this to be fair and reasonable.
Hi, in this segment of our training, we're going to be covering issues regarding to age discrimination in the workplace. The Age Discrimination in Employment Act of 1967, also known as the ADEA, essentially prohibits employers from discriminating against any individuals who are between the ages of 40 and 65 years old. It is important to note that in 1978 and 1986, the Act was further amended to provide for further language that would give workers in these work categories further protection. If we take a look at the case of O'Connor versus Consolidated Caterers Corporation, the U.S. Supreme Court unanimously ruled that any employee does not have to show that he or she was replaced by someone younger than the age of 40 to bring suit under the ADEA. The case began in 1990 when James O'Connor's job as a regional sales manager was eliminated. The company did not select O'Connor, who at the time was age 56, to manage either of its two remaining sales territories. He was later fired and was replaced by a person who was 40 years old. Now, let's shift and take a look at age discrimination and our labor market composition. Prime-aged workers between the ages of 25 and 54 years old have the strongest ties to the labor market, and it has been said that many of these baby boomers make a large makeup of the labor force. Also, many of this portion of the labor market has been graying, and these are trends that will have to be addressed along with issues related to age discrimination. If we take a look at statistics from the Bureau of Labor, you will see a key demographic of workers between the ages of 55 and older. In 1990, 12% of the labor force was comprised of this work demographic. And if you take a look at 2020 projections along with 2050 projections, you will see that it will spike to over 24% of the labor force. It is important to address age discrimination in the workplace. 1 in 5 workers in the U.S. between the ages of 55 or older has said that they have seen or experienced workplace discrimination. This is 64%. Age discrimination claims filed with the EEOC have also seen a spike. In 1997, claims filed with the EEOC numbered 15,875. If you take a look at 2014 numbers, you will see that the claims have spiked to over 21,000 claims. In this day and age, with companies and organizations aggressively moving to cut labor costs, individuals over the age of 40 who command high salaries may be vulnerable to reduction in force or layoffs. Also, many of these workers may be passed up for promotions or may not get pay raises. Another thing to consider is the Great Recession. This Great Recession has caused many older workers to delay retirement due to retirements essentially being erased. These are all issues that will need to be addressed in the near future to protect firms from legal action.
So this section here that we're speaking about is gender discrimination. So discrimination based on gender or sex is a common civil rights violation that takes many forms, including sexual harassment, pregnancy discrimination, and unequal pay for women who do the same job as men. Examples of gender discrimination in the workplace. This is something that's really important to go over so we can make sure that we don't do this in the workplace. A potential employer asks discriminatory questions based on gender during the interview process. They can also claim that an employer failed to hire, failed to promote, or wrongfully terminated an employee based on his or her own gender. Unequal pay claims is another one that's very big when it comes to workplace discrimination regarding gender. And the last one can be claims for sexual harassment of employees. This section is going to be talking a little bit about some of the regulations that have been put in place against workplace discrimination. The first one is Title VII of the Civil Rights Act of 1964. This prohibits discrimination because of race, color, religion, sex, and national origins. The Equal Pay Act prohibits sex-based pay discrimination between men and women who perform under similar working conditions. Age Discrimination in Employment Act, ADEA, prohibits discrimination against employees age 40 and older. Americans with Disability Act, ADA, prohibits discrimination against qualified employees or job applicants with a disability because of their disability. The Pregnancy Discrimination in Employment. Employers may not discriminate against a female employee based on a pregnancy.
It's our responsibility and legal obligation as an employer to maintain a workplace that is free of sexual harassment. The consequences of sexual harassment in the workplace result in low employee morale, costly lawsuits, and low productivity. As such, there are many strategies and procedures a company must implement to prevent sexual harassment. To begin with, we must create a company-wide sexual harassment policy that is published in the Employee Handbook. The policy should define sexual harassment in a clear and concise language that all employees will understand. The policy should also express that there is zero tolerance for sexual harassment in the workplace. On the same token, the policy should lay out disciplinary actions for employees who do not abide by sexual harassment in the workplace. This may be suspension or termination. In addition to that, the policy should identify procedures for sexual harassment complaints and explain how complaints will be handled. Employees must understand that their employer does not take this issue lightly and will investigate and treat all complaints with high importance. Our managers and supervisors are some of the most vital representatives of our company. Therefore, it is their responsibility to train and inform their subordinates about the company's sexual harassment policy. In order for them to do that, they must be well versed in the policy. The company's human resource department should conduct several workshops to adequately train top management about ongoing sexual harassment policies and issues. By doing so, supervisors and managers will be educated and will be able to properly train their subordinates about this key topic. Their strong stance will show employers that the company stands by a culture of no sexual harassment. Managers and supervisors who have great knowledge in sexual harassment will be able to properly monitor and safeguard the workplace.